Hello and welcome to COS Indiana Live as we bring you Roundtable. The Roundtable segment is presented here every fourth Monday of the month at 7 p.m. We'll be focusing on education and discussion of the topics and challenges we all face as we use the Constitution to save the Constitution. Join us now as we bring you COS Indiana Roundtable with our MC, John Ackerman.
Welcome to Convention of States Today Roundtable. I'm your host, John Ackerman. This is broadcast number 277 of Convention of States Today, and our topic is the Bill of Rights, Don't You Dare, Part 3. First of all, I want to bring on Ken Kashuba to talk about this QR code that's up here in the corner. Ken, are you there?
I finally am here, John. Thank you very much.
There you are. I remembered your last name this time. Last month, I couldn't think of your last name.
I appreciate that very well.
Tell our viewers about this QR code up above me here.
Certainly. That QR code, for if you're new to viewing COS today, is all about joining our subscriber list. And that's really just a way of saying we support the programming. And we want to be able to offer you some educational videos, materials, and also a lot of our contributor segments are being viewed there, along with our Indiana newsletter and some other things that have been added to that recently. So if you scan that little QR code with your smartphone and put in your name and email address, you'll join an elite group of people that get to see firsthand what goes on here at COS today.
Yeah, and I'm part of that group, and I would like every one of our viewers also to be part of that group. So we'll keep that QR code up there for the duration of this broadcast. Thank you, Ken. You are the State Communications Coordinator in Indiana. Well, let's bring on the rest of the panel. We've got about 3 more people to bring to the screen here. Brett Sturley, the Convention of States Director from the great state of Missouri, joining us for the third part of the Bill of Rights, Don't You Dare. And Brett, I want to thank you for coming all the way from Missouri to help us out with this important series on the Bill of Rights.
Well, I appreciate the invitation and having me for the third time. So apparently I haven't messed up too bad yet. So I always love joining you and your team.
And Dale is our regular Convention of States Today host. He takes a back seat during the roundtable, but he participates in the roundtable. Good evening, Dale.
Good evening, John. Merry Christmas.
And Merry Christmas to you too, and to Debbie Stewart. Glad to have you with us again. And this is really cool. Really cool because we've all been together for all 3 parts of the Bill of Rights, Don't You Dare. Now, the reason there's 3 parts is that originally we thought we could cover all of the prohibitions that are placed on the federal government in the Bill of Rights in 1 hour. And when we looked at the vast amount of content there, we said, can't do it in 1 hour. So we stretched it to 2, and then it became 3. Now, in the last 2 months, we looked at 13 things that the federal government is forbidden from doing. That's why the title is Don't You Dare. 13 specific actions that are spelled out in the first 5 amendments to the Constitution. And tonight we're going to focus on amendments number 6 through 10 and find out what else the federal government dare not do. The 6th Amendment, I'm going to hand this first part over to Dale to talk about the first phrase in the 6th Amendment, which says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. Dale, take it away.
All right, John, thanks. Well, speedy trial. Let's talk about first the speedy trial. Of course, the definition of this is that the accused has the right to a speedy trial to ensure that the individuals accused of a crime are not subjected to prolonged incarceration or legal uncertainty without being brought to trial. Sounds good, doesn't it? Okay. Well, the purpose of this, of course, is to prevent undue delays by the government. It protects the accused from extended periods of stress, stigma, or inability to prepare a proper defense, and also then helps ensure that any evidence or evidence remains fresh, witnesses are available. So that's the purpose for this, for having a speedy trial. Now, how do they assess this? How do they carry this out? Well, the courts, consider several factors actually. The length of the delay is taken into consideration. Of course, the reason for the delay. Is it unreasonable? Is it complex in any way? And also whether the defendant has asserted their right, or has asserted their right to a speedy trial, and whether the delay causes any prejudice to the defendant. So that's how the speedy trial is conducted. Some examples. I searched for some examples of how this has been misused, and I'll tell you the one that comes to my mind, of course, is the one we've been covering here on COS Today for some time, and that's the J6, the January 6 individuals. I've interviewed some that have been in prison for over a year and yet to be tried. And how that happens, I don't know. But so there's rampant misuse of this throughout the January 6th individuals. So that's a prime example in my opinion. Okay, let's talk about public trial. Well, again, the definition, the right to a public trial ensures that the court proceedings are open to the public, including the media, and providing, of course, transparency and accountability. This being a public trial prevents abuses by judges and prosecutors and law enforcement. Of course, promotes fairness by allowing the public to scrutinize, and helps build public trust in the judicial system. And believe me, the public trust is really, really wanting, I think, right now. But
it is.
That's a main purpose for ensuring a public trial. Well, yes, there are some exceptions to this, and some of the exceptions are when national security is at stake. We can understand that. Or when the privacy of the witnesses is a major concern, especially in the case of minors or the identity of other witnesses. So that's a good reason for the trial not being public. And of course, to prevent any interference in the trial, especially if it's a trial with a great deal of public exposure, public influence. So those are reasons for a public trial not being public. Now, has this been misused? Yes, of course. And once again, I go back to the J6ers. And evidently, I have learned that yes, these were public trials, but I didn't see any of them. They certainly didn't televise them. So I guess they have the leeway to decide what just how much of a public exposure they want to have. But so I fall back, John, on the J6ers as the example.
Okay.
There. So
okay, thank you, Dale. Well, that's
Okay.
the first. That's the first phrase in the Sixth Amendment. The next phrase guarantees our right to an impartial jury, and I'm going to lean on Dale again. Would you talk to us about the impartial jury guarantee of the Sixth Amendment?
Okay, so you're going to pick on me again, then, huh? I gotta do another one here. My God.
Yeah, you need picked on tonight, buddy.
All right. Okay, well, let's talk about some of the elements of an impartial jury. Now, I think we understand what it is meant by an impartial jury. You should have a defendant has the right to a jury that is not biased in any way, that has, as best as they can determine, without any preconceived opinions about the case or about the defendant or any of the witnesses that are going to be coming about, and that they should solely decide upon the evidence that is being presented and solely decide based on the judge's instructions, which that has become kind of controversial here lately on some trials that we're aware of, right? Right?
Yep.
Well, another element to this impartial jury is the representative, the cross section of the jurors. The jury pool should represent a fair cross section of the community, without discrimination based on race, gender, ethnicity, or socioeconomic status. So, should be a fair representation of the community, and of course, this jury then should reflect the community values. Okay, and ensure that certain things are not excluded. The jury should be free of external influence, and certainly you can think of outside sources like the media, public opinion, or from other concerned or parties that want to try and have some influence on this. They should be exempt or protected from those types of influences. And then there's a process called voir dire. Okay, now this is spelled VOIR and DIRE. The voir dire process. Okay, what that means is that potential jurors can be questioned and called to go through a questioning period to determine if there are any biases or conflicts. So that's a right that we have, that defendant has, and of course the attorneys from each side have the right then to question those jurors. So that's pretty much it on an impartial jury. And once again, I come back to the January 6th people. And the reason I'm doing this is I've had in some of my interviews, I've had defendants that January 6th defendants that went through the trial process. Some of them chose a bench trial. They didn't want a jury because they knew where they were located, which is Washington, D.C. They knew the jury would not be fair. They felt that the jury would not be fair. So they chose a bench trial. The ones that did try a trial by jury, some of them told me they literally heard these prospective jurors comment about how they thought he was guilty, or they were dead set against this proceeding in this case, but they were still selected as jurors. So once again, I use the January 6th case as a prime example of how this can be misused. And but once again, according to this amendment, the defendant is warranted an impartial jury.
Okay.
All right.
Thank you, Dale. Yes. And those two things are in the Sixth Amendment, and there's a lot more in the Sixth Amendment. We're going to move on to the next clause of the Sixth Amendment, and Brett is going to talk to us about the fact that it guarantees us the right to know the nature of the accusation against us if we're charged with a crime. Brett?
Thank you, John. Yeah, this whole amendment, and we talked about before how the Constitution and the Bill of Rights all link back to agreements back in the Declaration of Independence, and a lot of this with legal process and due process links back to several grievances and violations King George III was guilty of through in inflicting on the colonists and the new soon to be new states. But I think on the nature of accusation, there are some different elements that have to be present, and this is just specifically a statement of what the alleged crimes that the defendant committed were, and they have to cite in the indictment the specific crime that was allegedly violated. It has to have a statement of the individual statutes that were violated. So you have that statement as well. So you can link right straight back to it directly to one of the, like in Missouri, one of the Missouri revised statutes, or a federal, in this case, a federal statute, since the Constitution applies to the federal government, not the state government necessarily. A statement of facts of the case. From a lot of times this comes from like a probable cause report or a statement from the investigating officer or the investigating legal authority of what the circumstances were involving the case that brought the charges to the defendant, and then an allegation of a specific criminal behavior that the defendant is alleged to have participated in that caused this this allegation of violations of criminal code. And some examples. Most of the time, this transpires and unfolds the way that it's intended to, but there are some violations. And again, Dale was speaking a little bit before, the January 6th defendants. There are some, if you follow the reporting of Julie Kelly has been on top of these trials in a lot of the J6 defendants from the very beginning. I have a friend here in Missouri who is a lawyer for one of the January 6th defendants, and there are still defendants. There are still people that are being incarcerated right now in the D.C. Metro Jail that have not been formally charged yet. So they don't specifically have a list of the allegations against them that have been properly presented to them. And now, we're what, 2 years into this now, maybe even 3 years, closing in on 3 years.
Wow. So
this is just terrible. But I do want to point out another federal trial where we have a recent example where this has not been followed, and that's in Donald Trump's New York case. They call it the hush money trial. It's not hush money. He signed it's a non-disclosure agreement that was agreed to between Donald Trump and E. Jean Carroll, and the allegation was made by Alvin Bragg, the New York Southern District prosecutor, or district attorney, that President Trump misclassified this non-disclosure payment to E. Jean Carroll and should have counted that as a campaign contribution. And so they specifically cited the violation in New York state law, but then that was a misdemeanor under New York state law. Incidentally, nobody has gotten prosecuted under that law that I have heard of in the history of the law. But then they elevated it to a felony by citing, well, actually not citing, by alleging that there was a federal election law that was violated, and that's where this is what made this a felony in order to get the 31 different indictments. Well, these weren't 31 different actions. These were 31 individual entries of the same transaction. So the alleged violation was only happened one time, but it was documented in the Trump organization's accounting books 31 times. That's where the 31 felonies came from. However, that underlying felony has never been cited. It's never been specifically named. And
that's right.
It's interesting to point out that the Federal Election Committee looked into this prior to the New York case, and they investigated and said, there's nothing here. Even Alvin Bragg's predecessor, Cyrus Vance Jr., who was another liberal Democrat prosecutor, district attorney there in the Southern District of New York, investigated this and said, yeah, you know what, I'm not going to bring any charges. There's nothing there. Alvin Bragg initially said that he was not going to bring any charges until he got pressure, I believe, from a member of the Biden Department of Justice that went to his name escapes me here right now. I had it on my tip of my tongue a second ago. That decided to step aside. He was number 3, I think, in the Biden Department of Justice. He decided to step aside and go to the Southern District of New York and help out Alvin Bragg. So I'm sure that was just, he did that for family reasons or something like that, Sure. But coincidentally, after he went to the Southern District of New York, then Alvin Bragg decided to bring these charges against President Trump. Again, the underlying alleged felony or violation of federal election law has never been cited. And even in Judge Juan Merchan's jury instructions, he said that he instructed the jury that you can find him guilty, and you can find him guilty by 3 or 4 different things. He didn't even specify the underlying crime. So, you can kind of come up with your own theory, and the jury didn't even have to be united on the theory of what the felonious act was. They could just say, yeah, I think President Trump committed a felony under these conditions here, so I'm going to go ahead and vote. I'm going to go ahead and cast my judgment as guilty. So just a huge violation of due process and the Sixth Amendment. Yeah. And I think it's important to know, just briefly, I'll close here. We hear about, we've been talking about these violations. And you're thinking, well, it's right here in the Constitution. It's right here in the Bill of Rights. How is this happening? And, the point the framers made is that the Constitution is just a parchment barrier. It is completely, it's not worth the paper it's written on without the political will to enforce it. And I think that's really the key. And that's something to where, it comes all the way down to we the people, and the people that we elect as representatives and the people who represent us in government. And I think, we are really the enforcement mechanism that puts the teeth in the Constitution, and we'll get into that a little bit more when we get to the 9th and 10th Amendment. But I think that's really the key. It's incumbent upon us to make sure that the Constitution is respected and followed.
Okay, that's a great explanation of that freedom, of that right that we have, and a great explanation of some egregious violations of that. Okay, believe it or not, we are only halfway through the Sixth Amendment. We've got the second half of this thing, and we're going to start with Debbie. Debbie, talk to us about the guarantee for the accused to be confronted by witnesses.
Yeah, okay, so the purpose of what they call the Confrontation Clause of the Sixth Amendment is that it protects the criminal defendant against a conviction without an opportunity for that defendant to test the accuracy of the testimony of witnesses against them in front of a jury. So it gives the defendant the right to object to the witness's testimony and confront them face to face. Now, back in colonial days, when there was an issue, a person typically talked to a person. There was yelling and shouting. We didn't have all the lawyers we have today. So we use something called cross-examination now. So that's really where this comes in to confront the witnesses. It only applies to criminal prosecutions. It's an important tool to protect themselves from damaging the witness's testimony. Okay, a little bit of history is that this was written in response. The founding fathers wrote it in response to injustices and abuses in the criminal trials in colonial times. And it was influenced by the English common law tradition. And some of the things that would happen back then with the colonial times, sometimes they would conduct trials in secret. The witnesses weren't always required. Sometimes there were unfair juries. There's all these things going on. So the founding fathers saw that, wanted to make sure that this was in here. So I thought that was, they noticed that, specified that, got it in the amendments. An example of government abuse in this would be United States versus Estes. And I know we could probably put the J6 thing in every one of these, but some of these I didn't do that. You're supposed to be face-to-face, but they admitted a 911 call recording placed by the defendant's girlfriend. And it was held, the confrontation clause was not implicated, and the district court did not abuse its discretion in applying a hearsay exception. Wow. So they allowed that to be used when it wasn't face-to-face. So there's questions around hearsay and face-to-face, but this was one of those where they allowed that in there. So there's question, was that really the right way to do that?
Okay. Thank you, Debbie.
Yeah, you bet.
The next phrase of the Sixth Amendment says that if you're accused of a crime, federal crime, you have the right to compel witnesses to help your defense. You have the right to subpoena witnesses, and Brett is going to explain that one.
Well, thank you, John, and Debbie. Thank you for that excellent explanation and some background in history. And this part will be a little bit is a little bit more brief. The defendant has the right to subpoena witnesses, as Debbie was speaking, that the prosecution puts on their witnesses. The defense counsel has the opportunity to cross-examine those witnesses. But then once the defense has the opportunity to put on their case, present their facts, then the defendant has the ability to call their own witnesses, either to challenge the facts of the case, or can call rebuttal witnesses to rebut the testimony of the witnesses that the prosecution had called, and when they presented their case. And so that just gives the defendant basically a fair shot to dispute and to present their own case and demonstrate how the prosecution's case was possibly flawed, trying to introduce some element of reasonable doubt in a criminal trial, or to specifically rebut maybe expert witnesses that were presented to the jury or to the judge by the prosecution. So they say there's two sides to every story. Maybe there's even more than that. This gives the defendant the opportunity to defend themselves and present their side of the story and their explanation of what happened, of what happened, and just provide some type of defense that maybe they're not guilty of the crime that was charged, or maybe the conditions were that they did act incorrectly, they did violate a law, but it was a lesser charge, and that kind of goes back to whatever was cited in the indictment. They might claim the facts that there was a lesser crime committed, but not the higher crime that was alleged.
Okay, that's very interesting, and to me, the teeth in this clause is that you, the defendant, are guaranteed the power to compel witnesses to come and testify on your behalf. You can't just ask them to, you don't have to just ask them to come or hope they show up, but you have the power, the same power the prosecutor has to call witnesses. The Sixth Amendment says that the accused shall have compulsory process for obtaining witnesses in his favor, and that's a powerful thing. And I don't know if that's ever been abused or not. I've never heard of any cases where it's been abused, but it's a powerful thing. Well, we're just about halfway through our hour here, and so we're going to take a little break from this. And since today is 2 days before Christmas, we're going to get some Christmas greetings from Marengo Mike.
Young man, back in town for round two. I said, young man, there's a lot left to do. I said, young man, time to roll up your sleeves and remove those deep sea creatures. Young man, now the country's with you. I said, young man, now we're no longer blue. I said, young man, yes, it's time to make way for those future generations. Yes, we're wrapping up the final Marengo Mike's Corner for 2024. And Donald and I want to wish you a very Merry Christmas and a Happy New COS year. We'll see you soon.
Well, Marengo, you have outdone yourself. Thank you and the Donald for bringing us these Christmas greetings. Makes me
John, I just want to go on record. I have nothing to do. I had nothing to do with that. I had nothing to do with that. Okay, I just want.
Well, I know who did, and his initials are KK.
Yeah.
His last name there now, John. Come on.
Ken Kashuba.
I'll tell you, he never ceases to amaze me. His creativity.
That's a winner. Okay. Well, we're going to go on to the final clause of the Sixth Amendment, and it has to do with the assistance of counsel. You have the right to obtain that. And so, Dale, would you talk to us about that one?
Yes, this. I'll try and keep this one very brief, John. We've all heard it said that you have a right to a lawyer. Okay, so the defendant always has a right to a lawyer. And that is true. That is guaranteed. And that the lawyer, the defendant has the right to a lawyer in all the different stages of the trial. The initial questioning, the hearing, the trial itself, sentencing, everything that the defendant has the right to that lawyer. And the defendant has a right to counsel if they can't afford one. Obviously, one of the rights of the defendant is to choose their own representation, their own attorney or lawyer, whatever term you want to use. But if the defendant can't afford that, then they have a right. They still have a right to representation. So the government or the court must provide legal representation free of charge to the defendant. Yeah. And not only provide legal representation, but the representation has to be competent and effective. Has to be someone that knows what they're doing. Okay, so the defendant has that right. And of course, I mentioned the defendant has the right to choose their own representation, their own attorney or legal. And the defendant, according to this amendment, does have the right to represent theirself. And we've seen this not very often. And quite honestly, I can't find, I couldn't quickly locate any instances that we would all be really familiar with. There are some cases in history that I certainly wasn't familiar with, but I know this has been done, but I've never seen anyone turn out good and when they represent themselves like this. But I know it has done very, very infrequently. And like I said, I haven't seen any cases where it's turned out for their benefit. So that's pretty much it as far as assistance of counsel, according to this amendment.
Well, thank you, Dale. And that Sixth Amendment includes all the things we've been talking about here for this last 30 minutes or so. Big, big rights. And some of them have been abridged by federal, state, and local government. And that ought not be. We need to, as Brett was saying, we the people need to rise up and demand that piece of paper be followed. The guarantees that we have in the Sixth Amendment. So we're going to move on now to the Seventh Amendment, which is a lot shorter than the Sixth, and there's only two important clauses in it. The first one is trial by jury. Brett, take it away.
Well, thank you, John. I appreciate. Am I the only one who was thinking about my cousin Vinny going through the through the Sixth Amendment? Okay.
That's right.
Okay, I'm not the only one. Okay, all right.
Yeah.
So, the Seventh Amendment, I want to just read it here, just real quickly. The Seventh Amendment states, in suits at common law where the value and controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall otherwise re-examined in any court of the United States than according to the rules of common law. So, a lot of our procedures, especially judicial procedures, came from British common law, and that's where this had come from as well. So, as far as trial by jury, the accused can choose to be have a jury trial, or as Dale mentioned a little bit earlier, have a bench trial to where they just appear in front of a judge. And this trial by jury is applicable to civil or criminal trials. And the one thing to remember is that this sets up the trial by jury right at a federal level. So this is not necessarily applicable to state courts constitutionally. However, state courts duplicate this and do have jury trials and bench trials depending upon the violation. If you have a motor vehicle violation, you're not going to have a jury trial there. You'll go in front of a judge and plead your case, and then the judge will issue their decision. If you do have like a criminal trial, then that you do have the ability to choose either a trial by a jury of your peers or a bench trial. And recently, an example of a defendant choosing a bench trial to forego the jury was in the murder of Laken Riley in Georgia. And the defendant in that I'm not going to say his name because I'm not going to repeat his name. I don't want to give him any kind of notoriety or glory. The defendant in that case who was convicted chose to just appear in front of a judge and just have a bench trial. And the reason why you would choose to appear in front of a judge instead of a jury of your peers is that the facts of the case are so egregious, and maybe possibly the publicity that surrounded the case might be to the point to where it's going to be really difficult to have an impartial jury seated to begin with. But then also, like I said, the facts of the case are just going to be so straightforward and so compelling to where a jury might come back you might actually, have a little bit better chance with the judge maybe finding some technical flaws or some technicalities that weren't followed in the arresting process or in the arraignment process or something like that, that maybe the jury would not find. So that the defendant did choose to appear in front of the judge and was convicted, thankfully, and that is just one example of why somebody might choose a bench trial instead of a jury trial.
Okay, thanks, Brett. Now, Debbie's going to take us into the second and only other clause of the Seventh Amendment, guaranteeing that we can't be re-examined or put into double jeopardy. Debbie?
Double jeopardy in the Fifth Amendment, that you can't be tried for the same thing. And we call that double jeopardy, but they tend to give it a little bit of a different name because we're talking about the evidence here. No fact. So it's the re-examination clause, and this applies only to civil cases. And it's that no fact tried by a jury shall be otherwise re-examined in any court of the United States. So this just prohibits federal judges from re-examining any fact tried by a jury, except according to the rules of common law. It prevents federal judges from overturning jury verdicts in certain ways. And actually, if you look up statistically, less than 1% of civil cases are decided by a jury anyway. So that's very interesting. The Seventh Amendment only applies to the federal courts and not to the state courts. And that common law that they're referring to refers to the law and procedure of the courts that uses juries. Okay, so that's their definition of common law. So that's really all I have around that whole re-examination clause is you just can't, use the same evidence. I can't re-examine them. And that is really a protection for you going through a trial like that. So there was a case called Gasparini versus Center for Humanities Incorporated. And prior to the Gasparini case, the Supreme Court interpreted the Seventh Amendment, and they did allow federal trial judges to use. But what happened in this case was, without getting into all the details and just kind of summing what was the verdict there, was the Supreme Court removed the Seventh Amendment re-examination protection in diversity cases now in federal appellate courts. So they kind of expanded once again where you have a right taken away in another area. So that was kind of an abuse of that power.
Yeah.
Yep.
That's weird. Okay.
Yeah.
Well, thank you, Debbie.
Yeah.
Now we move on to the Eighth Amendment, and there's only one thing that it talks about, excessive punishment. Here's what it says. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. And this is Debbie's turn again.
Okay. So you already read it there. So really it prohibits the federal government from imposing excessive fines, excessive bail, and cruel and unusual punishment. And this amendment, this clause, serves as a limitation on the state or federal government to impose unduly harsh penalties on criminal defendants before or even after conviction. A little bit of history is almost identical to the English Bill of Rights of 1689. And there was a man, this whole thing was kind of inspired by a man named Titus Oates. And he was tried for multiple acts of perjury that led to a lot of people getting executed that he had wrongly accused. So they were really mad at him, okay? But the thing was, they sentenced him to like so many years in prison. But get this, every year he was taken out for 2 days for pillory. So in the stocks, with his arms and his head and everything. And 1 day of whipping while tied to a moving cart. So every year that happened, 2 days of pillory. And so it was barbaric, excessive, bizarre, right? So that kind of was a motivator. Before 1962, states were not subject to the Eighth Amendment. But in Robinson versus California, the Eighth Amendment applied to the states because they said because of the due process clause of the 14th Amendment. And an example, of course, the January 6th prisoners is a great example because, we've heard things about solitary confinement, not a lot of food, lots of these things that we've heard about that are just horrendous, right? For an American citizen by their own government, which is crazy. But another one was, it was a case called the City of Columbus versus Freeman. And this was in 2005. And a man named Freeman was arrested because he was operating a house of prostitution in Columbus, Ohio. So it's against the law. He was not a criminal per se, as in he wasn't a dangerous man. But the state set the bail at $1 billion and the judge agreed to it.
Wow.
Yeah. So, this is a great example of, come on, people, $1 billion, that's just crazy. So, yep.
Okay. Wow. Got some eye openers there.
Yeah.
Okay. That's the Eighth Amendment.
Yep.
The Ninth Amendment is similar in its brevity, and it says that your rights are protected, and it gets a little tricky in there. So I'm going to let Brett explain what's at stake in the Ninth Amendment.
Yes, thanks, John. The Ninth Amendment is brief. It's just one sentence. It just says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Basically, that's a late 18th century way of saying that just because we don't name a right in here that's specifically reserved to the people doesn't mean it doesn't exist. And this was really the argument between the Federalists and the Anti-Federalists in the 1787 convention. The Federalists, probably heard of the Federalist Papers written by James Madison, Alexander Hamilton, and John Jay. They were all examples of Federalists, and they had the position to where they were definitely pro-Constitution, but they were wanting to, they were more in favor of having a strong central government and more power consolidated in that central government. The Anti-Federalists, and some of those Anti-Federalists are maybe a little bit lesser known. They and like Patrick Henry, he was a prominent Anti-Federalist. Robert Yates, Richard Henry Lee were some of the examples of some of the Anti-Federalists, and their opposition and their problem with the Constitution is that they were worried because that there weren't enough individual rights that were specifically cited in the Constitution. That their argument was that if we don't specifically state what individual rights are, then the federal government is going to take those rights. There's not going to be a prohibition or against the federal government acting against those individual rights. And obviously, that was going to be difficult. You can't list a list of every single right that is reserved to the people. So that is where the statement was made that federal authority, the federal government had 17 specific enumerated powers, and the argument that the Federalists made were that the federal authority is limited and defined, but the rights reserved to the people are various and undefined. And what came about, this is really the reason why we have the Bill of Rights, this tug of war, this push and pull between the Federalists and Anti-Federalists, because there were several clauses that the states wanted to have drafted in the actual original Constitution, but there were points of contention between the states. If you think back in 1787, you had Rhode Island that did not send any delegates to the 1787 convention. Massachusetts was kind of split on whether they would actually ratify the Constitution or not. And New York earlier in the convention tried to take the convention over and lost two of their delegates. They just went home, and so only Alexander Hamilton remained behind. So it was really unclear whether the Constitution would be any Constitution would be ratified whatsoever, because that you had to have 9 of the 12 states actually agree to it. So you remove those 3 states out, you're already at 9 states. You lose one more, then we don't have a Constitution. So the deal was made between the Federalists and the Anti-Federalists, and brokered by James Madison. That they made the deal that, hey, you know what? We can't get all these clauses and specifically state all these rights in the Constitution because we won't have a Constitution that will be ratified. So in the first Congress, we will take up these specific items that the states wanted to include in the Constitution, and we will push them through the amendment ratification process, which is what they did. There were, I think, 17 proposed amendments. Actually, 12 made it through through Congress, and 10 were ratified by the states, and that's why we have the Bill of Rights that we're talking about here right now. So that this is what the Ninth Amendment was for, is just because there isn't an individual right that's specifically stated in the Constitution, that doesn't mean it's not reserved to the people. The limitation is on the federal government. Yeah.
Okay. Thank you, Brett. Now, to drive that point home, they also adopted the 10th Amendment, and it specifically talks about the rights that belong to the states and to the people. And I'm going to turn to Debbie again to talk to us about that.
Yeah, thank you. So the 10th Amendment says the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states, respectively, or to the people. So basically, the 10th Amendment reserves to the states those powers that are neither delegated to the federal government nor denied by the states in the Constitution. And so the Founding Fathers' intention was they really wanted to give the majority of the power to the states, but they knew that we needed to have a limited, small, defined federal government with some issues like military and, things that, interstate commerce and things like that. We had to come together on that. But now in our situation is this flipped. The federal government is huge and the state government's power has been dwindling now for a while. Why did the Founding Fathers want the state governments to have remain mostly with the majority of the power? Now, we know the federal government, we talked about this a couple months ago, the enumerated powers of the federal government. There's probably only like 20 listed, and that's it. Yeah. That's all they're supposed to do. Yeah. So the states' rights, they believe the states' rights were linked to the stability of the United States. And even Jefferson said a republic is evidently restrained to a very narrow limits of space and population. He said about the size of a New England township. That's how big the federal government should be. Thought that was interesting, right? Yeah. The Founding Fathers wanted state sovereignty because remember, they all started out as their own states, right? Yeah, yeah. And so, and then George Mason said only the states could check the arbitrary abuse of power. So I thought that was great. So what's an example of the government abusing this? Well, there was a case in 1997 called Prince versus the United States. And the federal government violated the 10th Amendment when Congress required state and local officials to perform background checks on people buying guns. You might have remembered this. They forced state officers to carry out federal law, and a man named Jay Prince and another man named Richard Mack challenged this constitutionally. And it's interesting, the lower courts said that it could not be constitutionally required for these state officers to perform the background check. So they did the right thing. But then the Ninth Circuit Court came along and reversed it and said, no, you do have to do those mandatory checks. And they won. Yeah. And that's my dog saying Merry Christmas to everybody.
Oh, that's nice. Well, the 10th Amendment is big, and I think it's overdue for a rebirth. We need a rebirth of the 10th Amendment in our nation. Well, friends, this brings us to the end of this month's roundtable. Before we close it out, I want to give you our email address. If you have any questions about Convention of States, you can email them to us at that address, raiseyourvoicecos@gmail.com. That's raiseyourvoicecos@gmail.com. I want to invite you to tune in next Monday, December 30th at 7 p.m. Eastern for our next Convention of States today, which is going to be a best of. In light of the New Year's Eve holiday coming up, we're not going to do a live one. It'll be a replay of a best of. That's next Monday night. And get this, the next Convention of States Today Roundtable will be on the fourth Monday of January. That'll be January 27th at 7 p.m. Eastern. And we're going to take a look at President Trump's 10-point plan to dismantle the deep state. And I'm looking forward to exploring that with our panelists and sharing it with you on January the 27th, 2025 at 7 p.m. Eastern Time. And with that, we want to say have a very Merry Christmas. Christmas is day after tomorrow. This is airing on December 23rd. And we wish you a very Merry Christmas and a Happy New Year. And now to close us out, here's an episode of COS Basics on the redundant safeguards to a convention.
Merry Christmas, everyone. Merry Christmas.
Merry Christmas.
Merry Christmas.
Merry.
John Aukerman for Convention of States, Indiana, continuing with COS Basics. Today, I borrow another point from attorney Rita M. Peters. There are numerous redundant safeguards on an Article 5 convention process. Attorney Peters lays out 4 safeguards. Okay, 4. Number 1. The scope of authority for the convention is defined by the topic specified in the 34 applications that trigger the convention. Any proposals beyond that scope would be out of order, and any single delegate could object to their consideration. Number 2, even if no one objected to an out-of-order proposal, and/or even if the convention delegates had installed a parliamentarian who refused to sustain an objection, state legislatures can recall any delegates who exceed their authority or instructions. This is because convention delegates are the agents of their state legislature. That's a legal term. They are agents of the legislature, and they are subject to the instructions given by their legislature. As a matter of basic agency law, any actions taken outside the scope of the delegate's authority would be null and void. Number 3, even if a majority of convention delegates went rogue and state legislatures failed to stop delegates from acting beyond their powers, and Congress nevertheless sent the illicit amendment proposals to the states for ratification, the courts would declare the proposals null and void. And the courts have an excellent track record of enforcing clear, technical matters of procedure and law. Fourth and finally, even if all those protections failed, it borders on insanity to think that 38 states, the requirement for ratification, to think that 38 states would ratify an amendment proposed under these circumstances borders on insanity. And so I repeat attorney Rita M. Peters' point. There are numerous and redundant safeguards on the Article 5 convention process.